Good morning everyone. My name is Prateek Tyagi. I am a second year law student and I am currently interning under Sir Jeevan Prakash. Today I am going to discuss an important case, that is CPIO and Supreme Court of India versus Subhash Chandra Aggarwal. The case is mainly about whether the Office of Chief Justice of India comes under the ambit of RTI Act. Before moving to the facts of the case, firstly I would like to give a brief introduction about the RTI. What is RTI Act? So the right to information comes under the ambit of Article 19 of the Constitution, that is right to freedom of speech and expression. And to protect this right of the citizens, the government came up with the RTI Act in 2005. The main aim of the act is to promote transparency and accountability in the working of public authorities. There is also an important section that we need to know before moving to the facts, that is section 2H of the RTI Act. It states that which explains what is public authorities, and it states that a body or institution established under the Constitution or by any law made by the Parliament. Also, it has to be owned, controlled, or substantially financed by the government. Then only it can be called a public authority. So, if any of these three conditions is present, that is, it is owned, controlled, or substantially financed by the government, it can be called a public authority. Now, coming to the facts of the case. So in 2009, a Delhi-based RTI activist, Subhash Chandra Aggarwal, filed an RTI and asked whether the judges of Supreme Court have already declared their assets and liabilities to the Chief Justice of India. And this question was asked pertaining to a resolution that was passed in 1997, in which it was stated that all the judges of Supreme Court have to declare their assets and liabilities to the Chief Justice. However, the office of CPIO, that is Central Public Information Officer of the Supreme Court, refused to declare this information because according to them, Supreme Court is not a public authority. The matter went to Chief Information Commissioner, and a full bench of Chief Information Commissioner decided that the Supreme Court have to declare this information, and from here the CPIO went to Delhi High Court. Now in Delhi High Court, the single judge bench of Justice Ravindratyagi upheld the decision of Chief Information Commissioner, and stated that the Office of Chief Justice of India is a public authority and they have to disclose the information. He also gave an important statement that judicial independence is not judges' privilege, but it is a responsibility cast upon them, which clearly means that the judges are accountable to the general public, so they should disclose the information regarding their assets and liabilities. Also, the case from here went to Supreme Court, and in Supreme Court, there's the 5-judge bench of Supreme Court again upheld the decision of the Delhi High Court. And finally, the precedent that came to us is that the Office of Chief Justice of India is a public authority, and they have to disclose all the information, that is their assets and liabilities, to the general public. Thank you.